won't be with Judge Tomlinson today.
Okay, so now what do I have to do?
Call the juvenile court and get
Okay,
their Zoom information so that you can join their Zoom meeting, because it'll be a different Zoom meeting than this one.
do you happen to have their telephone number?
I can go get it for you.
Good morning. Are you Larry?
Let me get it to you.
You remember me from years ago? Caitlin Wilson, I'm the prosecuting attorney. That's fine. I know we keep sending different people. All right, so we're gonna have a sentencing today. Judge may ask you or me on your behalf if you have an opinion as to what they're doing.
Okay, are you ready for the number?
Okay, just a minute, okay,
Ready? Okay, it's 985
Fine.
okay.
2155.
Thank you.
You're welcome.
The statute would let the worst person who ever violated it go to jail for 90
Is there another hearing that's gonna take place? Because I can go back to my office and just do everything by Zoom.
I'll double check with him. This one is scheduled before, but we also have a Kevin Lindke sentencing hearing.
Yeah, when's that?
That one was supposed to be at 9:30. So I assumed he was gonna do this one first, but I don't know. I can double check with them and see if you're.
Well, you know, I mean, because there's no need for me to sit here
Right.
and watch whatever else is going on.
Right. No, I get you. This one was scheduled before that one. I just don't know because now it's almost 9:30. If he's
Right.
just gonna do that one, I'll
Right.
find out.
Yeah, because I'm only like 5 minutes away,
Okay.
so it won't be like.
A big deal.
Really
Okay.
mad at me.
Right.
I just want to give you my guess on what they're doing.
After this out, can we get into probation, community service to do?
The contempt sanction, the PPO sanction, different from a criminal action, states that he can be punished by jail and a fine. There's not a provision under the PPO law for a probationary term.
Even with everything he's doing and continues to do on the internet?
The law does not provide probation as a punishment for PPO violations. It just goes
So what are we looking at, some jail time and?
or a fine.
I'd rather see him do some time on this.
Okay?
He's got a couple more violations, one with Ron here and one with Ron's granddaughter.
Sure, I understand both of those things.
One of it up to Zoom said,
Okay, all right, so just look for me on Zoom.
Okay, yep, no problem. Thank you. You're welcome.
Mm-hmm.
Hi, can you hear me? What's your name?
Genevieve, contempt sanction for 22nd. Yeah, they should have that.
What is your name?
oh my,
What hearing are you here for?
for me?
Yes, you, on Zoom.
Oh, for Carmelo,
Okay. What's your name?
Rose Taylor Gates.
Okay. It's still just gonna be a few minutes on that one.
Guy just won't go off what's going on the internet. He could put some nasty stuff on it.
I know, I've been checking this thing.
Oh, looks like he's on Zoom.
You call in?
Lindke, yeah,
Okay, I told him to.
okay. Hi, Mr. Lindke, can you hear me okay?
Yes, ma'am.
Okay. It'll be
Can you
just a
guys-
minute.
All right, you can hear me okay?
Yep, I can hear you.
Okay. Video quality's okay?
Actually, I don't see you. Can you start your video?
Oh, yep.
There you
Yeah.
go. Can you see us?
Yep.
All right. All rise.
Thank you, everybody. Please be seated. Okay, so let's call the matter of Whitcomb versus Lindke. Mr. Lindke, I see you're appearing by Zoom. My understanding is that you believe that you may have contracted COVID-19?
My sister and brother-in-law both tested positive. They got the results back last night. My brother-in-law was at work, I believe late last week or over the weekend, and a person he directly works with tested positive. They sent him home. He's been really sick all week. My sister is also very sick. She actually is a nurse that screens for COVID, and they both got tested and they're in quarantine. But I've been staying at their house this week, so I just informed the bailiffs when I got to the court this morning of that, and they had me contact the courts.
Okay. Well, we're going to proceed with the sentencing here. We've already had a couple of attempts at this one and adjourned it. I appreciate your concern about your medical condition. It sounds like you have been exposed. Whether or not you have it, obviously we all know that's something that could be or could not be. And we'll kind of go from there. So why doesn't everybody give me your names for the record?
Thank you, Judge Kaylin Wilson, Assistant Prosecuting Attorney, on behalf of the petitioner Larry Whitcomb, who is seated to my right.
Okay, good morning, Mr. Whitcomb.
Morning.
Okay. And Mr. Lindke, why don't you give me your appearance for the record?
Kevin James Lindke. And then also, Your Honor, I have a preliminary matter I'd like to address with the court before we do the sentencing. It's a very serious matter that I think the court needs to be made aware of.
Okay.
I filed a motion. I just filed it. It's in the box because we can't get in the clerk's office, obviously. But I filed a motion to disqualify the court based on my direct knowledge of the court engaging in ex parte communications with Court Administrator Mike McMillan and an undisclosed member of the public. Mr. McMillan confirmed this information with myself and with my attorney, Mr. Ellison. Everything's contained in my brief concerning this issue. But based on this ex parte communications, I believe that this court may have violated Canon 3A4 concerning ex parte communications. And I would like to, litigate this disqualification motion before we move forward with anything else. And if the court's going to rule on it, I would like to immediately appeal to the chief judge on this issue.
Okay. So what I'm going to tell you, Mr. Lindke, is a few things. First of all, it doesn't work that way. You filed a motion this morning. You have to give the other side, in this case it would be Mr. Whitcomb, because if you're attempting to disqualify me in a case that he's a part of, you'd have to give him notice, and you obviously haven't done that. So it's not fair to do that. Second thing I'm going to say is you raised similar arguments against another judge of this court.
Good morning. Are you Larry?
Let me get a chance.
You remember me from years ago? Kaylin Wilson, I'm the Assistant Prosecuting Attorney. That's fine. I know we keep sending different people. All right, so we're going to have a sentencing today. Judge may ask you or me on your behalf if you have an opinion as to what they're
Okay, you ready for the number?
Okay, just a minute, okay.
Ready? Okay, it's 985
fine.
Okay.
2155.
Exhibit A, and I'm trying to file it, but the clerk's office is closed. I was trying to get it stamped today so I could get it served and precipice it, but things are a little funky right now with doing that, and so I wasn't really sure what to do. So they had me just put the motion in the box. I have 4 more copies. I can give one to the prosecutor, one to Mr. Whitcomb, and one for your honor, if you'd like.
There's requirements under the Michigan court rules, Mr. Lindke. If you're going to file a motion, there's a requirement to file it and then set a hearing. And there's the number of days you're supposed to file it. Filing it on the morning or attempting to file it on the morning of your sentencing hearing, that doesn't work.
Well,
So,
I'm not trying to push this hearing. This all just came about, so I wanted to file it timely. It's just everything came about this week and all the information was gathered this week. So I'm not trying to file it today to stop anything. It's just, it had to get filed today and I just wanted to make the court aware of it.
Okay. So we're not going to deal with that today. We're going to proceed with sentencing. Any other
Yes, sir.
preliminary matters?
Nope.
All right. So obviously I issued a decision on June 16th, 2020. I explained why I believe that Mr. Lindke, or why I found that Mr. Lindke had violated the personal protection order. What we're here about today is to conduct sentencing. So Ms. Wilson, what do you think an appropriate consequence would be for Mr. Lindke's violation of the personal protection order?
Thank you, Your Honor. I have had the opportunity to talk to Mr. Whitcomb about what he would like to see in this matter. He is requesting that the court impose a jail term. While we agree that in isolation, a conversation in the court hallway is not the most egregious PPO violation that could be imagined, this has been part of an ongoing pattern of interaction over a long period of time between Mr. Whitcomb and Mr. Lindke. And because of that, Mr. Whitcomb has been truly distressed and emotionally
Objection, Your Honor. This is not relevant. She doesn't get to give all this background. We've already litigated this case and the facts of this case. She doesn't get to say all this at my sentencing.
So actually, people can talk about things that they think contribute to the situation and help the court talk about how to fashion an appropriate sentence. It's
understood, but she's outside of that.
I'm going to overrule your objection.
She's
going to be able to continue. Okay. So I overrule the objection. Go ahead, Ms. Wilson.
Judge, to clarify, I'm not asking that you base a sentence on anything that you believe that Mr. Lindke has done besides this incident. I'm just telling you that Mr. Whitcomb feels like Mr. Lindke has had a significant impact on his life, and that's why. So I think that the things that the court should consider in this case are, in Mr. Lindke's favor, this is the first violation of this personal protection order. However, I think the court should also consider the length of time that the protection order was in place before it was violated. He was served with the order on August the 29th, and this violation occurred within the next 60 days. He couldn't even go 60 days without violating the personal protection order after he was validly served with it. Additionally, I think that this is a truly troublesome issue to Mr. Whitcomb, but I think that any PPO violation is also more troublesome because it's a violation of the court order. And it's basically Mr. Lindke thumbing his nose at the court system and at the court's ability to exercise authority over him. I guess I understand how someone could leave the courthouse and encounter a respondent in a PPO situation, say at the grocery store or some kind of neutral location, and feel like they could make comments and no one would ever find out and it wouldn't be that big a deal. But in this case, this event occurred here in the courtroom while he was present for a hearing on the PPO itself. So that occasion above all occasions, he should have been very conscious of the existence of the PPO, of his responsibilities under the PPO, and he should have basically been on his best behavior when he was inside the courthouse. Mr. Whitcomb was obligated to come to the courthouse to see his PPO proceedings through. So this isn't like the grocery store where he could have just left and walked the other way when he saw Mr. Lindke. So I would ask the court to take these things into consideration and impose a substantial jail term in this case.
Thank you. Mr. Whitcomb, anything you would like to say?
No, I think she both covered it.
All right, Mr. Lindke, anything you'd like to say before I make my sentencing decision?
Yeah, number one, Your Honor, any comments that I made to Mr. Whitcomb are actually constitutionally protected free speech. Number two, the prosecutor brought up an interesting point that within 60 days of this PPO being granted to Mr. Whitcomb that I violated. Is the prosecutor aware? Because I know the court has judicial notice, but Mr. Whitcomb wrote me a death threat letter 3 weeks after obtaining this PPO. So prior to this interaction him and I had in the courtroom or in the hallway, Mr. Whitcomb had published a death threat letter on Facebook and also personally sent me this death threat letter, which was the subject of an MSP investigation that the prosecutor's office refused to prosecute for lack of evidence, even though Mr. Whitcomb admitted to sending the letter. He's testified about this letter. Mr. Whitcomb is not affected by me, Your Honor. He actually engages with me and initiates contact with me and then runs to the court crying about it. His death threat letter was very clear that he was going to try to cause me harm. He called himself the equalizer. He called me a dope selling trash master. He said I beat women, and he pretty much said that he was going to kill me. And this court has done nothing about that. The prosecutor's office has refused to prosecute. MSP said a very clear crime was committed here, and so I don't understand Mr. Whitcomb's argument that I should go to jail for a statement to him when he confronted me in the hallway. He made the first statement. He stood in front of me. He did not have to leave the courtroom that day to do what he did. He did not have to come by me that day. And so any argument the prosecutor makes is really baseless, and more is their prejudice from their office than it is any argument of law.
Anything else?
No, and I would just ask, I don't think jail is appropriate in this. Some community service, I guess, if you're going to do anything. But, yeah, I really believe there was no violation here and that the PPO, wasn't even valid. And Mr. Whitcomb's actions in sending me the death threat letter only 3 weeks after obtaining the PPO kind of negates any position or argument that he has in this matter.
Okay.
Can I say something, Your Honor?
Nope, we already got your chance. So, I'd like to start making the sentencing decision by thanking the members of our community who took the time to contact me to share their thoughts and opinions about our proceeding today. I received in total 7 emails from 6 different individuals. I have printed them, and I'm going to include them in the court file so that nobody can accuse me of having ex parte communications, and so they can become part of the court record. Some of
I
them
object to this, Your Honor. I mean, I don't know what the court rule or what the basis of this is, but I feel this is an objectable something. I mean, you've already engaged in ex parte communications. You haven't disclosed these emails until my sentencing hearing. I've had no notice of these, no chance to respond to these. And for them to come in for any consideration in my sentencing or to be part of the record is completely out of bounds.
Well, first of all, Mr. Lindke, I just want you to understand they were all supportive of you.
I understand that, but
second of all, I didn't solicit these communications. I did not make a response to these communications, so they're not ex parte communication. Sometimes people decide they're going to send emails, they're going to send letters to the court, and my universal practice is to take those letters and put them in the court file because it's something that I've received. Everybody's entitled to receive those. I'm not saying that I'm considering them for purposes of sentencing because I'm going to finish my explanation here. I'm just mentioning that they're there. So you can object if you will, and if you want to file a motion to strike them at some point in the future, you can do that, and we'll talk about that. But they're going to be part of the court record. So, Michigan's Code of Judicial Conduct prohibits me from discussing a pending matter with members of the community, so I can't respond to those communications. I can't send a letter back that says, boy, you didn't get this or you didn't understand this. However, I do feel it's appropriate to reference them as part of this proceeding. In reviewing those emails, it was obvious to the court that there were significant misunderstandings about these proceedings, both in the underlying custody dispute and in this personal protection order matter that led to the hearing today. I would urge members of the public to read the decisions that I have issued in the underlying custody case, Moeller versus Lindke. That's case number 152153 DC. My opinion issued on June 16, 2020 will give you a comprehensive overview of those proceedings and put the present matter in its appropriate perspective. In this case, my decision keeping Mr. Whitcomb's personal protection order in place, which was issued on April 22nd, 2019, and my decision finding that Mr. Lindke had violated the personal protection order, which was issued on June 16th, 2020, will give you a clear understanding of what brings us here today. I think that review of those decisions will address all of the questions or concerns that were raised in the emails that I received. I'd also like to note that none of my decisions were necessarily the final word on the questions presented. The parties to a case have the ability to seek appellate review of any decision that I make. None of the decisions which I have made which have led us to our hearing today have ever been appealed, much less altered or reversed by the Michigan Court of Appeals. Turning to the exact issue that brings us here today, I determined in my decision of June 16, 2020, that Mr. Lindke had violated the personal protection order which had been given to Mr. Whitcomb under MCL 62950A-23. If I determine there's been a violation of a personal protection order, I, and I'm going to quote the statute, must impose a period of incarceration not to exceed 93 days. The things that I am specifically considering in determining an appropriate sentence for this violation are the following. First of all, Mr. Lindke mentioned the letter today. That letter has been the subject of proceedings before this court because Mr. Lindke filed for a PPO against Mr. Whitcomb using that letter as a basis. He also attempted to have this PPO dismissed because of that letter. Mr. Lindke abandoned those, or those requests were denied by the court, so I was aware of the letter, but it wasn't pursued to conclusion. I have no knowledge about what the prosecutor did or did not do. That's not within my purview or my decision. I would point out in my decision, I noted that any actions taken by Mr. Whitcomb, once a PPO is issued against Mr. Lindke, are not something that is relevant to alleged violations of the PPO by Mr. Lindke, and that was very clearly part of my decision. The allegation or the assertion that Mr. Whitcomb had spoken first was raised as part of that hearing. There was no evidence that supported that allegation. It was an allegation without evidentiary support, and so I rejected that. I pointed out that even if Mr. Whitcomb had said something first, there is case law in the state of Michigan that says that Mr. Whitcomb's actions, when there is a PPO against Mr. Lindke, are immaterial to the proceeding before the court. So it didn't matter if Mr. Whitcomb said something first or not, because Mr. Lindke still had to follow the requirements of the personal protection order, which I determined he did not do. So that issue, I think, is a red herring, and I don't think it is something. A bigger concern is the absolute lack of remorse that Mr. Lindke has for his own behavior. We've heard so far today that it's Mr. Whitcomb's fault, that everybody else is not doing what they're supposed to. Mr. Lindke at no point took responsibility for his actions, and that lack of acknowledgement of the violation, that lack of willingness to accept the consequences of his actions is very concerning to the court, because that is something that I have seen from Mr. Lindke in other circumstances, having presided over cases involving him since September of 2015. This incident was part of a long-standing and extensive campaign by Mr. Lindke to harass or intimidate Mr. Whitcomb. This campaign continues. There's another matter which is currently pending before this court. It's a hearing on petitions that were brought by Mr. Whitcomb against Mr. Lindke and others to seek issuance of a personal protection order for continued harassment. While many of Mr. Lindke's actions were protected by the First Amendment, and accordingly are not being considered by the court, not all were, including the actions that led to the issuance of the personal protection order and the actions which led the court to determine there was a violation. So some of the things that Mr. Lindke has done are protected by the First Amendment, but there are also things that he has done that are not, and those actions are the ones that lead us to where we are here today. The circumstances of this violation were a blatant disregard of this court's order and of the respect that should accompany court proceedings. While waiting for the commencement of the hearing, Mr. Lindke confronted and harassed Mr. Whitcomb in the hallway approximately 50 feet from the courtroom. If a person protected by a personal protection order cannot feel safe from harassment in the courthouse within sight of the courtroom door while waiting for a court hearing, what good does the order do? For other violations and related matters involving Mr. Lindke and his violations of court orders, the court has tried all kinds of different mechanisms. I've held sentences in abeyance. I have suspended them for good behavior. I have tried community service in lieu of incarceration. Those consequences have not resulted in any meaningful modification of Mr. Lindke's behavior or his willingness or ability to comply with court orders. So based on all those facts, I believe that the appropriate consequence for Mr. Lindke's violation of the personal protection order is incarceration at the St. Clair County Intervention Center for a period of 60 days, commencing today. Mr. Lindke, I'm going to have you report to the Intervention Center. You are to be there by 11 a.m. to commence your sentence. I will explain to you that they are going to quarantine you. They're going to be notified of the fact that you believe you may have been exposed to COVID. Their usual practice is to quarantine you for 14 days after you arrive there. And if you do contract COVID, then they're going to make a decision about what should happen. If you do not contract COVID, you're going to be turned into the general population at the jail once they determine that it's safe to do so. So report to the Intervention Center by 11 o'clock today.
Your Honor, can I request an appeal bond? Because I'd like to appeal this sentence immediately.
If you're asking me to give you a stay of the sentence, I'm going to deny that request. I don't believe there's an appropriate reason to do that. So I want you to report at 11 o'clock today so you can commence your sentence. Thank you.
Thank you, Your Honor.
Thank you.
I ain't going.